Hello, everyone. Welcome to our event, The Role of Constitutional Courts in the Promotion of Domestic and International Law. And thank you very much for joining us today. My name is Sara Razai, and I'm going to be chairing today's event on behalf of the hosts, the Better Justice Association and the UCL Judicial Institute. Now, before I introduce our speakers, I want to give you a short introduction to the paper that has inspired us, our event today. The Better Justice Association, led by Mehmet Gun, is an NGO based in Turkey whose work focuses on improving the country's judiciary by developing universally acceptable solutions to its problems. Now, over the last year, they have worked hard to produce a white paper which brings together concrete proposals for reform which could implement these important changes in the Turkish system. Now, Mehmet will talk you through their proposals relating to Turkey's constitutional court in just a moment. However, it is important to note that while these suggestions were drawn up with Turkey in mind, many of the issues raised may be and indeed are applicable internationally and are helpful to us in talking about other judiciaries and similar issues they face. We are also delighted to be joined today by Professor Tom Ginsburg from the University of Chicago, where he is a professor of international law and political science with a focus on comparative international law from an interdisciplinary perspective. And Dr. Silvia Citeu from UCL, where her current research interests are in comparative constitutional law and constitutional theory. Together, they will take us through their thoughts in constitutional courts whilst considering the international perspective. Now, if you have any questions throughout the event, please message the Zoom chat and we will ask a selection of the questions towards the end of the event. And without further ado, I'm going to hand over to Professor Tom Ginsburg, please.
Thank you so much, Sarah, and thank you, Mehmet and Sylvia also for allowing me to join this. I think it's a really important initiative, and I'm really looking forward to the discussion. I thought I would start by making some general comments about the current position of courts and constitutional courts around the world. Over 230 years ago, when the American founding fathers were debating our Constitution, they understood that there would be a power of judicial review. The courts would have the ability to set aside legislation. And Alexander Hamilton famously said, "This isn't a problem, don't worry about it. The courts are the least dangerous branch because they lack the purse and the sword," meaning that courts don't have any money, they don't have any military might, so they can't really take over a system. And you shouldn't worry too much about them. And that advice has been heeded in the sense that we have seen, more and more countries give more and more powers to courts. Judicial review in some form or constitutional review is now found in about 3/4 of constitutional systems, which is a huge increase since World War II. And most of those systems have designated constitutional courts, type that we're talking about today. That is a special body whose only job is, or his primary job is to review the Constitution. Along with this expansion in constitutional courts has been an expansion in their formal powers. Now we have constitutional courts doing things like reviewing impeachments, the removal of officials, making election disputes. So there's an increase in formal powers and then an increase in actual power in many political systems. And this is leading, of course, to what is sometimes known as judicialized politics, and sometimes even the politicization of the judiciary. That is, when you have a decision maker which has the ability to make major political decisions or major decisions with political distributional consequences, then politicians, come to it and try to control that institution. And that's something that we've seen very much in the era of democratic backsliding. That is, in countries that were, established constitutional democracies in which somehow one player or one party tries to take over the whole system. And we often see efforts to pack the courts. I would include the United States in that category. We've seen that. We sometimes see efforts to change the personnel, to fire judges and things like this, to expand or contract jurisdiction, and often, interestingly, to use the court as a mechanism to bless the other moves that the person or the party wants to make in taking over the political system. Because then you could say, oh, well, I know we did this controversial policy, but it's constitutional. So of course it's okay. So this is kind of the moment we find ourselves in. And that leads to the question of how to get truly independent constitutional courts, truly independent judiciaries, if we are going to leave so much power in their hands. And I place this proposal in that context. Now, I sometimes say that judicial independence is a bit like freedom. Everyone wants freedom. No one's against freedom. Everyone is for judicial independence. But it's a little bit hard to define exactly what it is. It's easiest to define in its absence. We know what freedom looks like when you don't have it, but what exactly it is when you do have it is not clear. And the same is true of judicial independence. What do we mean when we say someone is independent or a body is independent? Independent of, political authorities, surely. But we often have situations where the judiciary as a whole can be independent, but individual judges may be subject to pressures from within the judiciary, may be subject to pressures from outside. We have instances, of course, of corruption, which could result from a structural independence, right? Too much independence means no accountability. And so that is kind of the challenge of all judicial reforms. And we see judicial reforms, being proposed in many societies as we try to calibrate the level of autonomy that the judiciary has to have in our modern life, while making sure that they're not going crazy, either in service of someone trying to take over the political system or just going crazy on their own in terms of making decisions which are not really in the realm of the judicial power to make. So this is a major challenge. Now, I tend to think of reforms as falling into a couple of different camps. And I like to think about this as related to individual and collective reputation of different bodies. And let me just explain that. All of us work in organizations, and the organization thrives when we each work really hard. I write articles and books, and I want my name on them, and that makes me work hard. So that's good, I suppose, for the University of Chicago. Now, you could imagine a world in which I only put my name on it and not the university. And that would be a world where I didn't care about the collectivity. I would be all for myself and not for the broader body, which is essential to actually make my life function. The reverse situation would be where the individual gets no credit, right? Where all of my books are published with University of Chicago on them, no name. And of course, if that was the setup, you would see a lot less books. You'd see a lot less work by individuals. That is, in trying to design optimal production by teams, this is what economists call this team production, we have to think about ways to incentivize individuals while also making sure that the collective body is protected and gets its share, that people will invest in the collective work, because judging is, in fact, to extend the metaphor, collective work. It's teamwork. It's not the product of an individual judge. It requires deliberation by judges. It requires the production of the law in, over time in ways which is not really the job of one individual. We sometimes see judicial reforms which emphasize the individual. And we sometimes see judicial reforms which emphasize the team, the collectivity. And when I look at the proposals, which we are about to hear, I think that they really are in the latter category. That is, what the proposals are trying to do is to try to create a system of justice in which the individual judges may not be very well known, they won't be promoting themselves, but rather they'll be incentivized to contribute to the law as a collective good. Why do I say that? Well, as we're going to hear, one of the proposals for a mechanism for appointing the judges on the Constitutional Court would be, involve the supreme authority of justice, which is this idea of a kind of collective body of judges looking out for judges, looking out for judiciary and the law as a whole, rather than individuals. one of the parts of the proposal is to expand the number of judges and justices on the court. And that obviously tends to emphasize, the group effort. The chamber system emphasizes the collective, deliberative part of producing constitutional justice. So I tend to think that's a good thing at this time in the Turkish cycle, Turkish sort of state of the judiciary. I would contrast it with my own country. In my country, the judges join the Supreme Court, and they now join at a very young age. They are really political appointees, and they go through a process of public deliberation, some would say public humiliation through the Senate, in which everyone learns everything about them. And then when they're on the court, they sign their opinions individually. We in law schools spend all our time thinking, well, how is this person going to vote on this case? What's going to happen with abortion? Well, it's going to depend on what this justice does. And that obviously is a big distortion in terms of judicial independence and in terms of the law. Yes, the judges in the court are independent, but their legitimacy is under grave threat, and they're not really accountable to broader threats in this trends in the society. There's also too much emphasis on the law as the product of individual authors, rather than, as I believe, a collective product in which judges working hard put their best minds together to produce good decision-making in ways that, of course, will reflect the needs and the changing needs of the society, but will not be a judicial takeover, if you will, of the political system such as we're experiencing in the United States. So those are some quite general thoughts, but I do want to say that I think the effort of reform, which we are now discussing, is one that is permanent. All judicial systems, there's always discussions of reforms as we try to calibrate judges between being, independence, accountability, having a lot of power, a little less power. There's always demands for reform, and that's very healthy, in fact. But there's not a single right answer. It has to be fit to the particular needs of the judiciary and the political system at the time. And so, with that, I think with the Better Justice Association proposals, we have certainly an important idea for public debate in Turkey about exactly what moves need to be made now to ensure a better quality judiciary for the country. Thank you very much.
Thanks, Tom. That was really interesting. And I'm particularly grateful for your thoughts about maintaining the balance versus the judicial body, so the versus the collective. You can almost see reflected in, the civil continent, common law, legal systems tend to emphasize the individual from an age, right? Judicial activity emphasizes ones. I think that balance is something that Turkey has been grappling with, and I think a lot of other Western judiciaries have grappled with. When do we belong to which body, the collective, the individual, which should we have place emphasis on? Anyway, my ramblings. We're going to hear now from Mehmet Gun, the founder of Gun and Partners and the Better Justice Association. Gun is going to give us an outline of innovative solution in the 9-point plan and the importance of constitutional supremacy. Mehmet, the floor is yours.
Thank you, Sarah. And Tom, thank you very much for seeing it the way you presented to the audience. I totally agree with you that judiciary should be independent, but not too much independent to become arbitrary. They should be accountable. And the best means of accountability is to ensure that they earn and maintain the credibility before the public, not a small circle of people. You have a lot of other mechanisms to make the judges accountable, but the essence of our proposal is that we judge the judges and the judiciary by the quality of the work that they provide to the public. And our core idea of our reform proposals is to actually improve our judiciary to be able to produce quality of services. Of course, when we talk about quality of services, we also need to talk about the resources that we give to the judiciary. In terms of our proposals for the revision of, I would not call it reform, but revision of the Turkish Constitutional Court, we have developed some proposals, some of which I hope you will find innovative. Turkey has a constitutional court since the 1961 constitution. The court has 15 members, and the members serve for 12 years. 3 of them are appointed by the Turkish National Grand Assembly, and 12 members are appointed by the president. The president was a neutral person prior to 2017, when the constitution was amended and the president became the head of the executive. Then he became a political leader. So concerns about the impartiality and neutrality of the Constitutional Court has increased. Anyway, the court has a General Assembly, which has a quorum of 10 members out of 15, and 2 human rights complaint chambers. If you remember, Turkey adopted the internal domestic complaint process after so many caseload was, I think, choking the ECHR. So we decided to move them in the country and charge the Constitutional Court to deal with them. So basically, Turkish Constitutional Court has a lot of duties, and those duties, I think we can summarize them in 4 categories. One of them is obviously the conventional duty is to ensure and to review the constitutional law of the laws, and since 2017, the presidential decrees. The secondary regulations, the implementation regulations, constitutionality, are left in the hands of the State Council, which is an administrative court. For your information, Turkey adopts, differentiation of the courts. So we have civil courts, we have administrative courts, we have constitutional court. The other duty of the Constitutional Court is to audit the activities of the political parties. And the third one is to act as a supreme criminal court for immune people, like MPs and presidents and ministers, and also adjudicate on party closure cases. You are familiar that in our jurisdiction, we get a lot of this kind of cases in Turkey. And finally, as I mentioned, there's to review the complaints on human rights violations. The court's review of the constitutionality is post-mortem, so it is retroactive. After things have taken place, the court starts reviewing. But when the court makes decision, if for example, if it decides to annul a legal provision, that decision is not retroactive. It has its own effects after the decision has been made. The court currently faces several difficulties, and we believe that those difficulties need addressing. First of all, it has insufficient capacity. It has a lot of, I think it has a sufficient number of rapporteurs, but especially after 2010 amendment with the human rights violation complaints, I think the capacity of the court is insufficient. And it has made some controversial decisions, and the constitutional courts need to be controversial because they need to face the whole establishment against themselves. So as a result, they received a lot of criticisms, and also one political party voiced that it should be transformed into an old-style high court type of court. The public confidence is eroded, has been eroded, because number of factors conflicting, contradicting the jurisdictions of the court, and also some courts have shown this erosion. saying that they will not comply with the decisions of the Constitutional Court, even on human rights violation issues. Everybody, I think, in this country believes that the Constitutional Court and its members are under political influence. There may be loyalty issues as well as politicization of the court. For example, in 2010, when an amendment was taken to the Constitutional Court, they took one sentence, one word out of a constitutional amendment, which meant the Constitutional Court making its own, constitution. So we believe that the decision was politically motivated, and as a result, public confidence and trust is ailing. We are proposing that in the first place, to make the court the sole authority to deal with all constitution-related matters. So we propose to increase the workload of the court even further. We propose that the court acts as the appeal court for the Supreme Court of Justice, which we propose again to make the decisions of the Judicial Council subject to judicial review, and that the judicial review decision should be appealed before the Constitutional Court. We think that the Chief Public Prosecutor, whose duty is to commence proceedings before the Constitutional Court, should be separated and improved. And we also think that not only a limited number of people that commence constitutional review, which is 3, the president, the ruling party and main opposition party, plus 1/5 of the of the Grand National Assembly commence proceedings. We think that every member of the public should be able to commence constitutional review. Of course, there will be thousands of cases, but as we have seen in the class action example of the United States, those cases can be consolidated and resolved very quickly. We also think that any constitutional issue, for example, for the constitutional law of the implementing regulations, should be trusted to the Constitutional Court as opposed to State Council. We cannot have 2 different interpretations of what the Constitution says or does not say. The duties of the court, as we propose, needs to be increased. But to deal with the increased workload, I think we need to increase the capacity and improve efficiency, consistency, and neutrality of the court. For capacity and efficiency improvements, we are proposing that the court's members are increased to 30 from 15. Currently, it is 15. To organize the court in 3 different chambers plus the General Assembly. So we have 3 chambers and 1 General Assembly. We propose, in order to eliminate the political influence and motivation in the appointment of the members, to reduce the political. Sorry, my English is going sometimes bad, but let me rephrase. We are proposing that political motivation should be annihilated in the appointment of the members. So we are proposing that the 3rd chamber of the court deal with the human rights complaints, and the second and first chamber deal with ordinary and conventional issues. And the members should start, newly appointed members should start with the third chamber, which means also a learning opportunity for the new members, and then promote towards the second and first chamber as the members in the first and second chamber retire. We also think that first and second chamber members should rotate 1/3 by every year, so that consistency and neutrality can be increased. We are proposing, as Tom mentioned, that a transparent appointment system of the members of the court, as well as the other high courts. It should ensure meritocracy, which Supreme Authority of Justice should actually act as the body that ensures and shares with the public the meritocracy information, and also all process from the candidacy to appointment is open, transparent, and subject to judicial review. We think that when all these happen, when members are increased to 30 members, when the chambers are organized in the way we propose in 3 chambers, and neutrality of the appointment of members are realized, then the court actually eliminate all issues of criticism against the court, I believe, and earn respect from the public and its institutions. Only then the court can effectively improve the protection of basic human rights, hinder violations of those rights, and also become a trusted guide for the society. The society, especially in our country, needs guidance, trusted guidance from the courts, especially because it is their duty in their struggle to improve the rule of law in the country and also improve the democracy to the best and most advanced levels as Turkey requires. Turkish people realize that there is a great link between the rule of law and efficiency and accountability of the judiciary with the economical success. So this is what we propose and why I propose. I hope it is helpful.
Thank you so much, Mehmet. We're going to hear from UCL's Dr. Silvia Suteu now, who's going to tell us a little bit more about bridging the gap between constitutional courts and existing political systems. Silvia, the floor is yours.
Thank you very much, Sarah, and thank you to all. Thank you for having me on the panel. So my focus will be on constitutional courts, more so in transitional contexts and contexts of new democracies, with a special focus on Central and Eastern Europe, which is one of the areas on which my research focuses. And I thought what I would do was actually bridge or address the link between questions of institutional and constitutional design, which my predecessors have already touched upon, and questions of judicial and constitutional culture, as well as perceptions of judicial authority, legitimacy, and independence. And what I will seek to explain is that these transitional contexts actually raise distinct problems of authority and legitimacy for constitutional courts, which in turn morph and persist over time in ways that interact with pathologies of the rule of law and which inform the need for reform. And I'll also argue that constitutional designers and practitioners must be aware of these distinct problems from the onset as they discharge their work. Now, first, a general note on constitutional courts' authority, legitimacy, and perceived independence. At a basic level, of course, constitutional court's authority and authority is established by the constitutional text itself, which recognizes the judicial power as one of the constituted powers, and also recognizes the role of constitutional courts as guardians of the Constitution. But we know, of course, that even in established or so-called consolidated democracies, the constitutional text is not always sufficient to underpin the full authority of the apex court, especially its powers of constitutional review. So from the time of Marbury v. Madison in the US and onwards, these apex courts have had to themselves claim and solidify their power to review and strike down legislation. And even in these so-called established and consolidated contexts, constitutional courts have had to be wise and, yes, strategic in how they discharge their functions in order to maintain not just their authority and legitimacy, but importantly, this perception of being authoritative, legitimate, and in turn, independent. And I will borrow a term from Rosalind Dixon, who has spoken of this type of principled judicial strategy as judicial statecraft, speaking of several steps that courts can take to ensure their own institutional strength, and in turn the effectiveness of their judgments, and then in turn the perception of independence and legitimacy. So think of things like the timing of issuing certain judicial decisions, the way in which these judgments address the losing party in a way that respects their position and is constructive and displays comity, constructing a narrative that addresses both global and local elements, engaging with the government and civil society as partners in the implementation of the Constitution, etc., etc. And she argues that such choices about the substance, the scope, and the framing of judicial decisions are even more important in newer democracies, where there will be less of a history of independent, powerful, and effective judicial review. And I would largely agree with that, but I think there are distinctive problems in these contexts that constitutional courts encounter that add to these elements, these strategies, and also modify the ones that she proposes. So I'll now give you a sort of a flavor of some of these different problems in transitional contexts that I have in mind. Now, in transitional periods, there will often be overlap between the previous legal order and the new legal order in an effort to avoid a legal vacuum, with the Constitutional Court then itself being tasked with piecemeal reform or piecemeal interventions to excise from the body of norm previous norms that are no longer compatible with constitutional democratic commitments. The best example from Central and Eastern Europe in this regard is Hungary's post-1989 transition, which avoided wholesale constitutional replacements and which left then the Hungarian Constitutional Court to intervene surgically and sort of perform this task of bringing the new legal order in line with democratic and constitutional commitments, a task it performed with great acclaim until it was co-opted, of course, during the Orban years. Another distinctive feature of transitional context is that there will tend to be a greater degree of gap filling that the constitutional courts need to do, and clarification of the constitutional text through interpretation. So especially in instances where the constitutional text leaves a great deal of ambiguity or even silence on important key questions, it will be for the Constitutional Court to perform this quasi-legislative, if not quasi-constitutive role. And to give an example from my own home country of Romania, that's where a lot of the conflict surrounding the Constitutional Court actually came from. So the Constitution contains a lot of ambiguity that hasn't been fixed through constitutional reform since 1991, which left the Constitutional Court tasked with having to play arbiter in a lot of, especially separation of powers, conflicts in deeply politicized constitutional crises as they were unfolding. So think presidential impeachment, where it had to rule on what popular sovereignty as exercised through a referendum that needed to validate presidential impeachment actually amounted to and required in very concrete terms. It needing to play arbiter between the dual executives, so between the prime minister and president, again in concrete cases where they were clashing, and other examples where it found itself in these deeply politicized waters having to give an answer, because as Mehmet put it, it needed to provide an answer and often to be in conflict with pretty much all the other constitutional actors. And that was a feature by design rather than an accident. So I think it's unavoidable that this gap filling and interpretive role that is heightened in transitional context will mean that constitutional courts in these contexts will then find themselves in these deeply political waters and also be perceived possibly as themselves politicized. I would also argue, though, that in some instances, constitutional designers did a rather poor job of anticipating that this would be the case. So it's not just the case of Romania, but for example, Bulgaria as well. When they set up the constitutional courts, the model that was envisioned was very much as an old school Kelsenian model of a non-political court that would really handle sort of high-level interinstitutional disputes, no access, no individual complaints access to the court, but somehow managed to both maintain this depoliticized, non-political identity while discharging this function of arbiter of interinstitutional conflicts in a new constitution without the tradition of cooperation and with serious questions of that needed clarification. So I think that's at best characterized as a paradox, to put it nicely, but one that didn't help because the institutional design didn't really match the constitutional reality that was bound to unfold. And an additional feature here that isn't often talked about in, I would think, in again, so-called consolidated democracies is that the constitutional courts in these contexts found themselves in conflict often not just with political branches, but with the ordinary courts themselves. So to go back to the Romanian example, the Constitutional Court really for its first 15 years or so was perceived very much as a foreign body, a foreign transplant in the system, in part because of the judicial appointments and who got to sit on the court, but also the role that it was meant to discharge, the perception that in a certain sense the constitution that it was meant to interpret was contain norms of a different nature than the sort of law, right? The legal norms that the ordinary courts were tasked with implementing and under whose authority they were operating. So it was perceived as a foreign body, as an other in the system, and that resulted in patchy implementation of its decisions, sometimes outright resistance and refusal to implement. So also within the system itself, and it took sort of years and years to gradually establish the authority of the court, the Constitutional Court, as a court that also really has the authority to protect constitutional supremacy. And I think those conflicts, interestingly, now also have a supranational dimension insofar as sometimes you have clashes between these courts be outsourced, for instance, to the Court of Justice of the European Union, with, say, the High Court seizing the Court of Justice of the European Union to really get a review of a Constitutional Court decision that it thinks was wrong, and trying to get an external arbiter for what is a domestic conflict still of authority. So where does that leave constitutional courts in transitional context then? Or in other words, is there a way out? Is there a positive take to offer here? I think returning to the idea of strategy or statecraft, there are strategic choices that constitutional courts can make, aided by smart design, that will improve their perceived authority, legitimacy, and independence. And I'll briefly emphasize two, and I'll leave it for the Q&A to develop if there's interest. I think one is the educational nature of their judgments, and the other is sort of being cognizant of their intended audiences. So for example, on education, explaining the normative basis for decisions is especially important in contexts where the norms of constitutional democracy are less established or were undermined by a previous undemocratic or autocratic regime. And I think this educational role needs to be discharged both vis-a-vis the wider public and vis-a-vis other courts, to get them on board and to get them to understand that there is a collective effort here that the Constitutional Court is part of, rather than that it's an antagonist to the other courts. And discharging this educational role will likely entail going beyond sort of formalism, and may also entail reforms of a different nature, perhaps allowing for dissenting or concurring opinions, allowing for different style of judicial drafting of decisions, etc. But those are all issues that can be explored, all to bring the judicial decision closer to, as I said, both the public and ordinary courts. And the model I have in mind when I say this is the UK Supreme Court's judgment in the Miller and Cherry decision on the prorogation, i.e. suspension of the UK Parliament, a judgment that was written in really plain language, that is very accessible, and that was widely sort of disseminated because of that, and became really a public document, not just a technical legal document, and that brought a lot of acclaim and improved the court's legitimacy at a very tricky political time in the UK as well. Thank you. I'll stop there.
Thank you so much, Sylvia. That was very interesting, and I really liked your thoughts, hearing your thoughts on the arbiter role of sometimes constitutional courts in a transitional context. One way probably which could be mitigated is that the arbiter becomes the educator in a way, or become that gatekeeper, or the one that kind of provides with education to the wider public through the judgments, through normative judgments. Now, thank you again. Thank you everyone for all of your contributions. I think we've really had some fascinating inputs, and I'd like to develop some more through a few questions to kind of try to bring all these threads together. So I think the first one, and I'll throw this one out there. So whoever wants to pick it up, just pick it up. So what are the key considerations when approaching the introduction of new judicial norms in countries where a reform is essentially taking place?
Well, maybe we should leave the floor to Tom. This is such a hard question, Sarah.
Tom, you want to have a go?
Well, yeah, I'm happy to take a crack. I mean, to speak very generally, key considerations. First of all, you have to understand the local context. I mean, the reform that we are talking about for Turkey might not be the same reform for Romania, even if the goal is, the same endpoint, because obviously you're starting, in different places, different reputations of the judiciary, different presence of capacity for what Sylvia was calling statecraft, different perceptions by the public. A really hard challenge is when you have a judiciary that's very weak and is perceived as by the public as being very dependent, because then why would anyone give them resources? You really need like a wholesale reform. You need to vet the judges, or do some major institutional change to change personnel in order to do something in that context. It's a very different problem when you have a very powerful branch that's maybe too independent, like the United States judiciary right now, where a different set of reforms is needed. So that's the first thing. You have to think about the context where you're coming from. Also, another just general principle is to think in every institutional design setting, what are the possible unintended consequences of the reform? Because there are always unintended consequences. And certainly for the Better Justice Association, that's something to spend some time thinking about. Like, suppose the proposal is adopted, what could go wrong? Always good to think about that, even though it's often hard to predict. What else might I say? Well, maybe that's enough.
Maybe if I follow Tom, I think thank you very much. When we were preparing these solutions for our judiciary's problem, is that we had to think a lot. Why are we reforming? Why do we want to reform? Where do we want our country to go? I think that's really important, especially for the constitutional court members, because they're somehow political. We treat them as judges, but they have somehow they have to take political choices, and making tweaks to certain provisions, and having a say on the trajectory of the country going forward is an important aspect for the constitutional courts. So the essence of our proposal is that the constitutional court should be a guide. It should be a trusted guide, especially for our country, being being a bridge between the Eastern and Western cultures, and also geographically being in the middle of various international balances, etc. a constitutional court member should be really aware of this and should really have a good feel and grasp of, how reforms are going to transform us, whether that transformation is a desired transformation or not, and then, guide the society, also use the power to annul the provisions in such a way that the country goes, takes a safe route. Of course, we are, as Turkey, we are proud of being a member of the international community, and we are proud of, maintaining the same or adopting the same values as international community. So, maintaining those values and principles at the same time, making sure that the country goes and transforms in the way that is not risky and also, maintain its position. So I think, that would be the main consideration for me. I personally do not agree that, judges or any people who are called judges should not have judge qualifications. But, I make a small exception for the constitutional course. Yes, they can be a little bit different, but they should learn, as Sylvie says, they should learn and teach, but at the same time should have a sort of, neutral political view about how the country should progress.
I'll jump in with a few thoughts as well, though again at a quite high level of generality. Going back to Sarah's question, I think first of all, recognizing the novelty of the reforms and then in turn the need to ensure broad understanding and commitment to them, right? So that they're not perceived as sort of reforms of one party trying to get its own way and, to sort of go against another or to vacillate between one side of the political spectrum or another. So it goes back to that neutrality, but really a sort of an effort, again, to educate the broader public and other constitutional actors as to what underpins these reforms, and that it is the public interest and a collective effort rather than partisan goals. I think what that means in practice for a constitutional court will be that it actually has to work, to itself work to do this work itself, which courts are not always very good at doing that or even willing to do that. But I think it's unavoidable precisely because constitutional courts especially find themselves at the intersection of law and politics, whether they like it or not, right? Another thing I would say is that the introduction of reforms may well entail a gradual process of them catching on. So the graft, taking, the transplant starting to work. And that is something that should probably be acknowledged from the onset and expectations be adjusted. That it's not all going to work as intended, maybe from day one, but that there needs to be a process of acclimatization. And again, I think educational or the Constitutional Court, again, taking its educational role seriously plays a big role here. And also collaborative spirit, again, taking all the constitutional actors on board. And finally, I'd say awareness also that previous norms and previous practices in institutional forms tend to be resilient and that there may be resistance that is encountered. Even once a reform, let's say, is formally adopted, that there may be resistance also in the, with a formal resistance or at the level of practice and informal operation of institutions where you don't actually yet have the new dispensation take root, and to plan for that possibility as well.
Thank you so much, Sylvia, and thank you all for that. I think a second question, so it's one that I've particularly been mulling over, is the degree to which one can improve that interjudicial dialogue, particularly the constitutional court vis-a-vis the other judicial organs. So I'm keen to hear your thoughts about that. Any structural reforms that could be done to improve that? I'd say also non-structural reforms. But I think this is one of those issues that really do pop up in the transitional setting, but also in countries not necessarily towards a democratic transition, but countries with a politically unstable climate.
I have one thing to say, which is I think a lot of times we see conflicts between new constitutional courts and old Supreme Courts. They often are, there's some obviously inherent tension, but a lot of times it results from poor drafting, poor constitutional drafting, or poor, design of the procedures, insufficient specification of the procedures whereby cases go back and forth. One way to kind of avoid that pitfall is in the design of the system, getting judges or scholars from both sort of sides, if you will, together to really work through the details as to how cases would move back and forth. And you can have reforms, you can have problems in all kinds of directions. In a number of countries, the ordinary judges say, oh, there's a constitutional court. That means we don't even have to apply the Constitution in ordinary cases. And that leads to under enforcement of the Constitution. In others, the Supreme Court insists that it has the duty to and can make final decisions, notwithstanding the Constitutional Court. So just all kinds of problems arise. And just really careful drafting is my answer.
Maybe follow the same order. It's becoming a ritual for us. As far as I can see from Turkish practice, this constitutional court is not at the top in the hierarchy of courts, as far as I can see. But being not in the same hierarchy, causes to a lack of discussion between the courts. We have seen a couple of examples when normal judicial courts said we're not going to follow the constitutional court order on human rights violation, which public roared and said how could that happen? Finally, the court complied with it. But this kind of reasons for discussion that leads to this kind of awkward situation, I think we need to avoid it. How do we avoid it? The way we avoid it is to make sure that everybody has to comply with the constitutional court order. What if the constitutional court has made an obvious mistake? For example, we have come across in relation to the advocacy law dealing with the professional associations for lawyers and professional associations with a public nature. We have this peculiar system here. The Constitutional Court made 4 decisions over a period of 20 years on the issue of democratic management of these, semi-public institutions, and said, in one case, this is undemocratic. The same thing happened in 5 years' time. They said this is democratic. Another 5 years passed. The court said this is undemocratic. And 5 years passed, when people complain about, past, difficulties, etc. Very recently, the court said again, this is democratic. This kind of discrepancy and contradiction, black and white contradiction should not be allowed in the Constitutional Court's jurisdictions because there has not been that much changes in the circumstances. So we need to find a way to address this. Currently, we don't have it. So because we have this kind of, contradiction in the decisions of the court, then the public confidence about the court erodes, and your question remains unanswered for Turkey. I don't know how to find a solution, but this is a serious issue that we need to find a solution to.
I'll jump in again quickly. I agree with Tom about the importance of good constitutional design. I think that extends not just to the degree of specification of the rules, but for example, also in making sure that the rules are tailored and sort of adequate for what they're intended to do. I'm thinking again of several examples from Central and Eastern Europe where, you know, the problem of competing courts and conflicts between them stems to or goes back to rules on access to the court, including the Constitutional Court, right? So because of the rules and who could lodge a complaint or not lodge a complaint, you'd have an issue be sort of constitutionalized or not, right? And it wasn't necessarily a feature of the nature of the dispute or the nature of the conflict so much as rules on access to the court, and then which court can you take it to. A bit of forum shopping type of activity going on, and you don't want that, right? You want the rules on access to court to be tailored to the nature of the dispute and to allow, for example, questions of constitutionality to reach the Constitutional Court as opposed to be stuck elsewhere, and similarly questions that are not necessarily constitutional or that also have a non-constitutional nature to make their way through the regular judicial system. And I would also think important to remind ourselves that, you know, even inter-court conflict and interinstitutional conflict isn't always a bad thing. I think for me, what is important is to see that disagreement between the courts or between different branches and the court be a reasoned disagreement, right? So to have good quality judgments that explain the reasons for the disagreement, as opposed to just having, you know, as Mehmet was saying, one decision now, another decision later, and no principled grounds to explain that evolution. So for it to actually be a principled disagreement, I think would be important, because then you can see the reason for it and you can hopefully diffuse the perception of it just being a political disagreement subject to you know, the vagaries of time.
Thank you, Sylvia. If any participants, members of the audience want to ask any questions, please feel free to drop a line or a question on the chat box. In the meantime, I'll pose another question, one that seems to be a bit controversial, but there seems to be a general sense of the ideal judicial template for when you, and that is often promoted at the international stage. So you have, you know, judicial virtues, etc. Can there be a template, an ideal template for, you know, or a template for that perfect judicial system? And if so, what virtues would that have? Tom?
I thought maybe we should let Sylvia go first this time.
Yeah.
Well, yeah, maybe actually. I'm sorry about that.
Mine will be a short answer to say no. You know, I mean, the values that we've all been talking about, you know, sort of clear authority and judicial independence, real and perceived, are all there, but they're at a general level. They're not the kinds of values that you're probably asking about in terms of translating them into a template. I tend to be very skeptical of templates. You know, as a comparatist, I think I can't help it. And also when it comes to setting up the judicial system, also because again, there were a lot of assumptions that underpinned the institutional framework that was set up in Central and Eastern Europe, and it was set up in sort of in the spirit of, we have it right, this is what you do, from, you know, definitely a constitutional court in the Kelsenian sense, with powers of constitutional review, with powers to intervene in everything from certifying electoral results to, you know, everything else under the sun, to the judicial appointments process, to means of judicial accountability, etc. So the framework seemed to be complete and all there. And then of course in practice it works, it doesn't work, and has pathologies that emerge sometimes decades later or interact in weird ways with the rest of the constitutional architecture. So for me, it's a very difficult question to answer in the abstract. I think, again, context matters. And also the constitutional context matters, because a lot of what we've been talking about, I see as interacting in very concrete ways with other constitutional rules and provisions. So for example, you know, and I'll end on this example, going back to the Romanian Constitutional Court, you know, on paper, it looks great and it should work in a way that yields a relatively sort of neutral, impartial body that discharges its functions well. But then you look at other rules in the Constitution and you understand then that, for instance, judicial appointments coming, 2/3 of judicial appointments coming from the two chambers of Parliament doesn't quite work when you find that those two chambers don't actually have properly differentiated roles and end up being subject to the same political majority at every single election cycle. So, you need to have a contextual approach, and you also need to have a holistic understanding of the Constitution before you sort of design a constitutional court or a judicial system in isolation from it.
Maybe to the same extent as these academicians that I'm sharing with pride, that I have studied the legal systems in northern countries and southern countries. I'm quite familiar about the Romania's problems as well as Slovakia's problems and Italy's problems as well. One can talk about, I was really surprised to hear that there was some political influence in the appointment of judges in Germany, where they have service courts. This is quite an interesting topic to talk about. But I think that we cannot have, a detailed template, but that we must have a template somehow. That template must ensure a legitimacy of, the system relies on, who legitimacy calls for responsibility to. I believe it is the society, and the society and all the stakeholders of the judiciary should be in control, at the center of the system. Of course, not to the extent that they can influence the judges, etc. The judicial council's model should be improved in such a way that the judicial councils are consisted of stakeholders, not, the members of the judiciary, plus members of the executive and the legislature. The second thing that must exist in the template is that a sort of accountability or rule of law system that ensures that the administration of the judiciary internally is subject to the judicial review. The judges do not need to be, or they cannot be always right. Of course, they make mistakes, and they have make a lot of mistakes. So there should be a system that their decisions is subject to judicial review and ensured that the most appropriate decisions are made. And the balances within the judiciary should be structured in such a way that independence and accountability should be spread throughout all systems. For example, the judges and public prosecutors should have their independent professional associations so that they can ensure that the central regulatory authority consisted of the stakeholders function properly. And, the influence, any attempt to influence over the judiciary is diffused to a great number of people so that the influence cannot be exerted. So if we ensure that the performance of the members of the judiciary is actually designed in accordance to quality service provision, then I think we can be there. And every country has its own history and habits that they can design it. But for Tom, I would like to say that any society, any constitutional democracy needs to have, first of all, solve the judicial problem. They should establish, first of all, a judiciary efficient, accountable, and deserve and contains and able to protect its own independence. That's the must. We have an idea of establishing a shura, a council that guides the regulatory body in the central, so that they keep abreast of all the developments and the needs in the society regularly, and they adapt their services according to the needs of the public. Once that is done, I think the most important part, especially for my country or countries with similar political structure, is how you devise the legislator and the executive. Out of three people, if the two of them get together, of course, the third one is going to lose the fight. So it is often the judiciary that loses the fight and loses the independence. But, there should be a sort of system that, legislator and the executive function in harmony, but, they cannot get together to suppress the third state power. And in that respect, my great, idea, I greatly support this idea, is that the executive power is too powerful. And I think that should not be given in the hands of one person or one group only. It should be institutionalized. It should, the policy making, the enforcement of those policies, and also introducing regulations in accordance with the policy and the enforcements, etc., should be divided, maybe 3 different categories. In my country, I propose that national security, national education, health, judiciary, and the media laws should be, on the policy basis, should be entrusted to, constitutional institutions, whereas the politicians should be entrusted for the enforcement of those policies. Regulatory authorities, we already have them. And also to make, an efficient working system between, the legislator, the politicians, and the executive, which are formed by the politicians anyway. To make an efficient working system, I think we should have, official platforms that, the members of the parliament gets together with the relevant sections of the executive. For example, the leaders of political parties, whether in power or in opposition, should be able to get together and maybe discuss with the, with the head of the ruling party, so that, the ruling party could gain, confidence, or, should be able to consult and make decisions informally, even if he makes the decision on its own. So this kind of, sophisticated structure needs to be, established in countries trying to improve their democracies. I think in that sense, I don't really admire, the American system a lot, but I have to accept that, your system of cooperation between civil society, members of the, House of Representatives, Senate, and also, executive body, is one example that we can work on and improve more. This is what my answer is to your short but very difficult question again, Sarah.
Thank you. Tom, any thoughts?
Yeah, very briefly, in terms of virtues, this is an obvious one, but the judges have to follow the law. And everyone who's a lawyer or has tried to judge knows that there's some room. That sometimes in hard cases, there's not a single right legal answer, but there definitely are wrong legal answers. And so that's the critical part of accountability. Now, part of the problem is judging is very technical. The law is technical. And so ordinary citizens, they might know the outcome of the case, but they can't always tell whether something was within the boundaries of the law, within an acceptable range or not. So this leads me to respond to Mehmet's intervention to remind us, I guess, that judicial independence and accountability aren't always matters only of institutional design, right? That there's cultural things, as Sylvia said, but also, actual politics of it. And in this regard, I think it's really important for the judges and the bar, the lawyers, to have a good cooperative relationship. In countries where judges and lawyers are close, when the politicians attack the judges, the lawyers will come out. A very famous example about 15 years ago was in Pakistan. You may remember the general tried to replace the Chief Justice, and even though many people were critical of that Chief Justice, lawyers came out in their suits and were protesting and reversed the decision. So that it's also the case that lawyers not only defend judicial independence, but they can keep judges accountable because they know when a decision is ridiculous and they can be the ones to monitor that. So I think that's something to cultivate, even though it's very hard to do institutionally. It's a cultural feature. And I suppose if we're going to get to what Sylvia was referring as statecraft, which, the judges should make sure that they're connected with lawyers in a way that's to both of their benefit.
Thanks, Tom. Yes, absolutely. I mean, lawyers in many respects are the gatekeepers between, justice and the wider society. I'm afraid that's all we have time for today. Again, thank you very much, everyone, for joining us. If you'd like to hear more about the ideas discussed today, they're available to read on the Better Justice Association's website, which is found most easily by searching for their name on Google. We're also planning on holding more events like this. So if you're interested in attending, please keep an eye out on the Better Justice Association's social media channels. In the meantime, thank you again for joining us. Tom, Sylvia, Mehmet, thank you very much. And I hope you enjoy the rest of your day, wherever you've been tuning in from. All right. Thanks, everyone.
Thank you very much. Thank you.